Triple murder with ambiguous evidence and accusations aplenty. The decision by the Supreme Court won't solve the murder, but it will help define once and for all what the Constitution means by the right to a speedy trial. The case documents the fact that it's almost impossible to have a speedy trial, as the founders of the Constitution probably envisioned, with today's system of appeals, which in this case themselves have taken years to resolve. Tom Jarrell, ABC News at the U.S. Supreme Court.
The hearing in 1970 was one of my strongest supporters. He's privy to all the facts. He has copies of all the facts and all the memoranda and the hearings which were closed to the public.
A secret because it's been brought out, it was brought out at the bail hearings in California, that it can be proven that Colette's ice pick wounds, that she was stabbed through Jeff's pajama top, and that the holes in the pajama top matched the ice pick wounds in Colette's chest. Now, according to Jeff's story, this was an impossibility because he was wearing the pajama top at all times. Furthermore, the government can prove from blood impressions on the sheet that Colette was carried in, that Jeff carried Colette in that sheet. There's blood impressions from the lace on her pajama and from his pajama in blood on the sheet. Now, he claims that he never had anything to do with such a thing, that he only examined them on the floor. None of his story holds together. I mean, none of what he says he did. He claims to have been attacked in the living room. He claims to have sustained 10 ice pick wounds across his abdomen. Now, those 10 ice pick wounds, nobody has ever seen. No doctor in a hospital ever saw them. I didn't see them. Mildred didn't see them.
But he was stabbed in the lung, all the way to the lung.
He does have one.
Wound.
He had one stab wound that penetrated the outer sac of the lung, which caused what they call a pneumothorax, which depressed the lung. I think it was estimated at somewhere around 40%. But it has also been shown that this is quite a simple procedure for a doctor to perform.
Even on himself?
Even on himself. I've done it personally, but I was constantly involved in one way or another. Two major points that have been uncovered.
Is pretty strong on both sides. We don't discuss it, say, at work, and yet the nurses, I found, are fairly protective of my time and phone calls from non-hospital personnel, phone calls from people who claim they're patients and in fact aren't really patients. I have several sort of protective mechanisms set up that just occurred from friends and business acquaintances, and we don't really discuss the case. But the few times that we have, I judge their reaction to be that they believe in me and they believe the court results in 1970.
Socially, have you run into anyone that has come up and discussed the case with a strong opinion, perhaps against you, or tried to engage you in arguments about the case?
Well, it's usually an uncomfortable situation. It doesn't get acrimonious. In most circumstances, people will sidle up and say that they read Time magazine, or people will say they're aware of what happened in 1970, and for the most part, they usually say they're on my side, and what's the government trying to do, and why has it taken them 7 years to get to the bottom of this? There have been a few very infrequent negative type of experiences with people. It's usually very unpleasant. It leaves you scarred again for weeks at least. It's sort of hard to get back on course for 24 hours or a week or 2 weeks, depending on how the interface occurred.
You've never remarried. I'm wondering if you had not been under the legal proceedings that you've been going through, do you think your personal life would have been different?
Oh, there's no question. I have to, this is purely
Proceeding, they did find new evidence of laboratory analysis of various things from the scene of the crime, and they contended that was the basis for the indictment. No. Hold it just a second. We had a question that just escaped me. Okay. Doctor, in the 7 years or so since this crime occurred, what have you been doing? What has your life been like?
Well, I think that
Is this something, a type of thing you had to live under as a constant fear?
yeah, we, of course, we were well aware that there was a allegedly secret grand jury meeting in North Carolina, and it met for a period of about 6 months. This was in 1974, and this was, of course, 4 years after I had been released from the Army and cleared of all of this. The grand jury was presented the same facts that were presented in 1970, except they were colored by a prosecuting attorney, and there was no defense attorney in the room, as there never is in a grand jury case. I was arrested here at my home in 1974. It's really a bad memory. I think to be sort of stripped and handcuffed while your mother's sitting in the room watching and crying and trying to get to the phone to call an attorney 4 years after we've been into this was a little outlandish. 3 FBI agents and then taken to Orange County Jail and transferred to Los Angeles County Jail to maximum security, $500,000 bail posted. I mean, just extraordinary things occurred every step of the way. I've been living and working here in Los Angeles now for 7 years, at that time 4 years. I'm director of a busy emergency department, and the FBI handcuffs me and throws me in the back of a car and drags me in the jail and puts a $500,000 bail on me for something that I've already been found innocent of. I mean, I think it's outrageous.
How about from the standpoint of the future? Once this case is resolved, do you think your life is going to change?
Well, I hope so. I think the emotional component is going to be there, but I think that the weight of the judicial process and just the weight itself, when that onus, when that black cloud is lifted, I hope that my life changes and my life is a little smoother and it's easier to live a life. I find that the case and the facts surrounding the case and the memories and the constant intrusions by the legal machinery, not necessarily my lawyers, but I mean essentially the prosecution, becomes all-consuming after a while, and every fact of your life is colored by it. And when you wake up and you go for donuts and coffee, it's in the back of your mind. And when you go on a date, you wonder, does the girl know? Do you have to tell her? Is she going to read it? How do you handle that? When you walk in to see a patient in the emergency department, 300 or 400 times, a patient has said to me, gee, we're sorry for what happened. And a few times the patient has said, you know, you shouldn't be allowed. An extremely difficult answer. I think that the easy answer is to jump and say, yes, someone in the Justice Department is out to get me. I think that may be one of 4 or 5 parts to the answer. I think that there are prosecutors in the case who are interested in instant fame. I think that the history of the case bears me out in that. As the prosecutors in each office changed, the case would be brought up again.
Okay.
Back and forth to Washington and in the Justice Department has created unease in the Justice Department, and they would like to keep going and see this thing through to a resolution at the Supreme Court level.
Do you think this murder case is going to ever be solved?
I think it could have been solved. I think quite clearly the evidence shows it could have been solved because people were in custody who apparently had something to do with the killings. On 3 different occasions that we're aware of, the same person twice and another person on another occasion were in custody. Were released from custody. Later on, information then led the officials to understand that they had probably an important person in custody. It's warned that evidence that clearly doesn't implicate me implicates me. So how can they take that same evidence now and try to show that it proves someone else is guilty?
Doctor, once this case is resolved, how will it then affect your life? The Jeff murder case will ever be solved. Professor Siegel, do you consider your client to have stood trial and been acquitted?
The answer is, Tom, because of the uniqueness of the military proceedings in 1970. What has happened is there was a complete and full court hearing, at which the conclusion of that court hearing, after court proceedings, which were 4 weeks, 4 full weeks in length, spread out over a period of several months because there was intervening investigation done by the court. There was a 2,000-page court record. There were 60-some witnesses called by between the defense and the prosecution. Each side put on every witness known to them to have any material evidence. And based upon that, there is no doubt in my mind that the finding was that the charges are not true and that there has been a decision in this case.
Colonel Rock also wrote, I believe, that he felt the case needed further investigation by outside investigative agencies such as the FBI. Didn't that, in effect, leave the case open or the decision not final?
It left the decision totally final as to Jeff Macdonald, because Colonel Rock, who was the presiding officer at these proceedings, made only 2 findings. The first finding was that the charges against Jeff Macdonald were not true. The second finding was that a woman who had been uncovered by myself and the defense investigators working with me was in fact a person whom he believed the civilian authorities should actively investigate for her complicity in the murders of the Macdonald family and on the serious assault on Dr. Macdonald himself.
As a lawyer, you know the wheels of justice grind slowly. As far as a murder indictment is concerned, what is a fair and speedy trial? Do you think that, obviously in this case you feel too much time has gone by, but considering the seriousness of this case and the data that the Justice Department has, how do you define what a fair and speedy trial is from your viewpoint?
Well, let me define it by how the prosecutors in the Macdonald case defined it. The investigation of the murders began on February 17th of 1970. By the 1st of May, the prosecutors had determined to charge Jeff, and by the beginning of June, the prosecuting attorneys for the Army were satisfied that they had assembled all of the evidence that they needed. And the answer is they probably had, because they had the services of all the Army CID investigators that they needed. They had the assistance of the FBI. They had the service of the Army CID criminal laboratory. There was absolutely nothing lacking, and they were chafing at the bit to go to the first stage of the military proceedings in 1970. And as I said to you, they put on something like 25 witnesses. At the conclusion of the hearings, Colonel Rock, the presiding officer, said, was there anything else that anybody thought he should hear about, any witness he should hear from? And the answer was the prosecutors had none. And to this date, Tom, there is not a single new witness, not a single new fact of any sort. So the answer is probably that from February through June was a sufficient period of time, somewhere between 4 to 6 months, for the prosecutors to be ready, and they should have been ready to go to trial, and this case should have been disposed of a long time ago.
Should the Supreme Court reverse the lower courts and say this murder indictment should stand, will you then move on another era into another aspect of it, on double jeopardy?
Yes, there's no question about it. There were 2 significant issues that we raised when the indictment came down against Dr. Macdonald. One was the fact that there's been a 45-month delay from the original bringing of the charges against him to the new indictment in January 75. But the other aspect is the fact that the military proceedings in 1970 constitute a finding in which there was an adjudication of the actual guilt or innocence. And Colonel Rock, in his finding, which was then approved by every level of command over him, had concluded that the charges were not true. And therefore, it tells us that that is in fact barred by the double jeopardy provision of the Constitution. I might also mention that the United States Court of Appeals, which threw out this case on speedy trial grounds, mentioned specifically that it thought that we had a serious constitutional issue on the double jeopardy ground, but they weren't going to decide it since one decision was enough at a time.
You're fighting.
Hold it, we're going to be running out.
Okay, fine. About two more key questions.